doing that. Procedural justice is the process by which an employee who is misbehaving and not performing at their peak, how we work with them and how we handle them. And it's the process, how you go around disciplining them to the point if they will not change their bad behavior, where we have to get rid of them. And so that's what procedural justice is a fancy term for generally here in America, progressive discipline. Progressive discipline is where we verbally counsel them. Then we might do a verbal or written warning, a final written warning or suspension, and then finally discharge, where you go through the process of trying to correct someone's performance when they're misbehaving to try to create more desirable behavior, in what they're doing. So mediation arbitration does show up on the exam, because a lot of countries use these two, and you need to know the difference between mediation is when there's dispute between in some countries it's mandated that you have to go through either a mediation or arbitration process. Mediation is when there is someone between the two disputing parties trying to negotiate a compromise deal, versus arbitration is when a judge listens to both sides' input and then issues a ruling. And normally arbitration is binding. And once a matter is arbitrated, it is resolved and it is settled. And it's going nowhere else. In fact, in America, if an issue is arbitrated, it cannot go forth into the legal system, or at least the legal system never accepts those. Handling complaints, open door policies, committee reviews, formal steps, arbitration. ADR is the term I want you to remember on your exam, and that's alternative dispute resolution. In America, the typical way, if an employee has a problem with their employer and it does not get resolved in the workplace, then the other option for the employee is to go hire a lawyer and sue their employer. Try to claim it was that their legal rights were violated when it comes to race or religion or color or sex or national origin or age or disability or some protected legal right. That's what they're going to be sued under. Well, ADR is the alternative to the legal system. So anything that is an alternative to going to court is called ADR. And the advantages, the pros and cons, this is where you need to, on the exam, by the way, they're not going to be as literal as I am in here. They're going to ask you to make sure you understand the concepts that they're quizzing you about on the exam. The way they normally determine whether you understand the concept is by asking you what the pros and the cons. What are the advantages and disadvantages of a concept? And when it comes to ADR, the advantages to ADR is faster. It resolves a dispute so much faster than a court case will. Courts take years before they get resolved. Second is, it's cheaper. Everybody pays less money. It's a whole lot less expensive to go through arbitration, to go through mediation, than it is to go through the court system. So faster, cheaper, and then the third point, which is the biggest point of all, it limits the hostility. I mean, I'm going to tell you, even as an HR representative, and you guys as HR representatives, you actually often are the point person if a case has to go to court. And you're the one that has to deal with the lawyers and go to sit through trial motions and go through depositions and all these kind of things. And I'm going to tell you, by the end of the couple of years that it takes, at least here in America, you hate the other person. So it keeps the hostility down. So if I can get this settled faster and cheaper, and it's resolved in weeks instead of years, then you know what? I'm not going to hate you as much, and you're not going to hate me as much. But the deal with court cases is by the time it's over, everybody hates each other. And nobody's friends anymore after that. But by doing this, then it does keep down the hostility. So ADR is anything other than, I mean, it could be open door, 1-800 numbers, suggestion systems, whatever. Now, we're going to find out later that going to some countries and asking them for criticism of their manager criticism of the process, criticism of the way the company runs things in that country, they're going to look at you like, have you lost your mind? It's not my place to criticize my manager, my company, my process around here. My job is to come in here and do my work. Certain cultures, see, Americans, we don't understand that. But in certain cultures, you don't question authority. If you do, that's rebellious. And we'll find out that depending on the culture and the question that you may see on the exam, we need to understand that when we're doing business in some of those kind of cultures. So arbitration, we've already said it's binding. At least here in America, sources where you can go, that the government provides arbitrators. Here in America, the joke I always tell is, and this is true, if you ever watch one of those Judge Judy on TV, and I know Bodana and Aki and Juliana, y'all have never seen these, but we've got all these trials. I mean, there's a judge on TV, and then there's two people come in. There's divorce court. There is people that are disputing property and disputing back rent and all these kind of different things. If you've ever watched one of those TV shows, those people are not judges. Those are arbitrators. They're not arguing points of law. They're sitting in there, and both sides bring in their version of the story, and then the arbitrator listens to both sides and issues a ruling. And that's all an arbitrator is. They don't have to have a legal background because they're not arguing case law. They're not arguing points of law. They're arguing what's fair or unfair. Employment policies. We've already mentioned at will down there towards the bottom I want to talk about, but disciplinary actions, progressive discipline we already talked about, take them through all the steps. Here in America, generally if you want to avoid court cases, you need to go through the steps of the process. Other countries have their own steps, but generally worldwide progressive discipline is accepted. You don't just arbitrarily go fire somebody. You warn them, you work with them, you discipline them, several steps. Each step of progressive discipline gets increasingly more punitive, but it gets them closer towards ultimately being terminated and fired. But there are some countries where it's almost impossible to fire them, which is why in many countries, like in Europe, in Japan, they're much more vigilant when it comes to screening candidates. In America, we interview somebody for 30 minutes and then we hire them or we reject them. In other countries, they will interview them for 12 months. I mean, they'll interview them a couple of times a month for a year because they're not going to hire them until they have vetted them and they have checked them out up one side and down the other. Because if they do hire them, and then they realize later we made a mistake, now you can't get rid of them. It's too expensive. It's too onerous. The law doesn't allow it. So which is why you've got to be very careful in those other countries. Which is why when you're opening operations in other countries, you got to consider this.
I was just going to say, we are an at-will state, but isn't that counterintuitive to our disciplinary process if we can fire for any reason, no reason?
Yeah, aren't we, even though we are here, the United States, the country by the way, there's like, last time I checked, there were like 9 countries still practicing the at-will doctrine around the world. That's all. I mean, just 9 of the bigger countries. And yes, while the United States is an at-will country, we still have all these laws, that says, even though I can fire somebody for good reason, bad reason, no reason at all, I still cannot violate their rights by firing them based on their race or their sex or their religion or national origin or color or handicap or because they're in the military or because they're in the union or because they're disabled or whatever, or because they brought a charge against my company. There's so many protected statutes now that have watered down the at-will doctrine that this is why we want the progressive disciplinary policy to make sure you've really checked and double-checked and triple-checked and you've got a sound paper trail to prove that I didn't do it based on your sex or your religion or your national origin or whatever. So we're trying to protect ourselves. Terminations, just cause versus at will. Again, in other countries, you can fire people in other countries. But you better have a really great reason. I mean, it has got to be that they are just flat out messing up. And they are flat out doing bad things to get rid of them in many other countries. Otherwise, you can't do it. Can't get rid of them. It's just not allowed. Nor are layoffs unless the ETO reasons. And I want you to remember the ETO reasons. Again, economic, technical, and organizational reason. You've got to go back under the Acquired Rights Directives. You got to go back and prove that the reason we're letting somebody go is for an economic, technical, or organizational reason. And prove, again, it mainly goes back to that redundancy issue that I've got to get rid of them. And that's why we're laying them off. Otherwise, they've acquired the right to their job and their pay level. When it comes to turnover, there'll be a little bit of math on your exam. Not a lot of math on your exam, but a couple of formulas. When we get to later chapters, there's some formulas like figuring some accounting type things, figuring what your net assets and whatever, return on investments, whatever. But here, when it comes to figuring and calculating employee turnover, the turnover rate are simply the number of employees leaving divided by the total number of employees. And then to express it in a percentage, then you say times 100. The example I've got here is you got 15 employees at the bottom of the page. 15 employees who left, say, in a one-year period. And the average number of employees during that one-year period is 300. So 15 divided by 300 equals 0.05. Or excuse me, 0.05. And then you say times 100, that means we had a 5% turnover rate for that period. That's all. This is so simple that it's almost insulting, but I want to make sure you guys know how to do that. It's the same exact formula for calculating the tardiness rate. Now, different countries have different tardy absence rates. It's more accepted in those countries not to be as vigilant in regards to attending work as it is in other countries. In America, you can get fired if you've got excessive absenteeism or excessive tardiness. Whereas in some countries, it's a common way of doing business. They're just not going to be there on time. It's the culture. And again, you have, even though that's the way we want to do business, it may not be that it aligns with the culture. And so we have to adapt. And that's called a culture rate to the culture. And a culture rate's a fancy way of saying adapting to or acclimating to the particular business practices of that area and to the culture of that area. One of the things I had to adapt to in Mexico was we were trying to run a 3-shift operation, except people would want to disappear for 2 or 3 hours in the middle of the day for the siesta time and for their breaks and all that. And we were like, but understand, we can't shut down for 3 hours because we're trying to run 3 8-hour shifts a day, and then everybody's sitting on top of it, and there's only a certain number of machines. So we had a lot of adjusting to do to acculturate them to our corporate culture. They had a national culture down there of one way, but we had to have a corporate culture and retrain them and reacclimate them to our expectations. And it took a little while, but we got it straightened out. Okay, so absence or tardy rate is figured by taking the number of absences or tardies in that period divided by the total working days of the period. In other words, example at the bottom. I got 5 absences or 5 tardies, whichever you want to say, divided by 250 working days, and that would come out with 0.025, and you multiply that by 100, it comes out 2%. Again, insultingly easy, but this does show up on the exam sometimes, so I want to make sure you know how this works. Illegal terminations. Even in America, you can still terminate someone illegally. In many other countries, you cannot terminate someone except based on state-mandated rules and laws. And often is for cause and only for cause. So the common practice of at will here in America, not practiced in most countries around the world. Some countries, yes. Most countries, no. So you cannot get rid of people without a very good, sound business reason. And if you do, you're going to pay and pay a lot. And you can get into legal trouble also. So constructive discharge in America is a type of, it probably is going to be illegal. And anyway, constructive discharge, retaliatory discharge, involuntary or coerced retirement. These are times that we might get in trouble in America, and may or may not, depending on your handle of the situation. Even though we've got an at-will doctrine that says I can fire you for good reason, bad reason, no reason at all. You guys remember what constructive discharge is from your days? What do you remember?
It's when you basically force someone to quit.
Yeah. Constructive discharge is when I create a situation that forces someone to leave. When I treat them so badly that I have constructed a scenario or an environment where they don't really have a choice. I mistreat them. Let's say they're being sexually harassed. And if they're being sexually harassed but the employer does nothing about it, even though the employer is supposed to do something about it, in that case, that could be a constructive discharge. In that case, the courts will treat them as if they were fired and terminated, even though the employee voluntarily quit. But they quit because they were under duress and under stress. They quit because the situation was constructed that forced them to quit, even though they didn't want to. And that's what constructive discharge. Retaliatory discharge is you cannot retaliate against someone for engaging in a lawful practice. Like if they bring a claim, like let's say that their wage rights are being improperly, they're not being paid properly. And so they go report the company to Wage and Hour here in the United States. And Wage and Hour investigates and then makes the company back pay them a bunch of money that the company wasn't paying them. In that case, that employee cannot be touched. But if the company fired them in retaliation for bringing a claim, which they have a legal right to do with the lawful agency of Wage and Hour, then in that case, that's a retaliatory discharge, and that's an illegal termination.